Good afternoon and welcome to our final quarterly update for 2025. My name is Peter de Ruiter. I'm an attorney at law at Pallas Attorneys at Law, and today I'm joined by my colleague Marcel de Vries. Marcel, also welcome.
Thank you.
So what are we going to talk about today? We got a couple of topics. We're going to update you on some legislation, and the main theme for tonight is acquired rights under Dutch law and changing employment conditions under Dutch law. And we're going to first discuss some theory about that. And then after that, we're going to discuss some relevant case law. And of course, at the end, we still have some room for questions from your side and hopefully some valuable input. So that is for today. If you have any questions, please feel free to ask them. Also during the webinar, they will pop up in our screen. And we'll try to answer them. I think we will save them until the end so that we can answer all of them. So that's for now. So let's start. So first of all, a couple of updates about legislation that is coming up. I think we're going to start with some changes in the European guideline for European Works Council. So Marcel, can you tell us a little bit more about that?
Absolutely, thank you. Yeah, so the first change that we want to discuss is actually a topic that we do not have on our list that frequently, and that's about European Works Councils. Since we do have clients with European Works Councils, we thought it would be good to inform you about a recent change that has taken place per the end of October this year. And maybe good also to briefly explain how European Works Council, the body actually relating to information and consultation when it relates to multinational companies, and actually the body representing staff in these multinational companies. EWC's, European Works Council, they do not have veto powers, so it's more that they may give an opinion, so that is more a limited right, you could say, compared to local works councils. But there is a European Works Council in place, a directive in place, I should say, already for many years. And it has been criticized also for quite some years. And why? Because it contains quite some vague definitions. It was also that there was limited possibility for the European Works Council to enforce their rights. And also it was difficult to have access to also seek enforcement of their rights. So that was the reason actually for making changes to the European Works Council directive. And one of the more vague definitions was relating to a very important topic, because the European Works Council comes in place and has also important rights when it relates to transnational matters. So actually matters which relate to impact of staff in more than one member state where you do have a company. But what is actually then transnational? Well, this definition has been broadened based on the new directive and the changes that will take place. And actually the new directive gives a broader definition stating that it not only covers decisions directly affecting employees in one or actually more than one member state as such, but also decisions that relate to employees in one country, but they may also have a significant impact on and consequences that are foreseeable in another EU country. So maybe to give you an example, if there will be a large scale redundancy in the Netherlands, impacting a lot of staff that will lose their jobs, this will have an impact, in my example, in the Netherlands, of course. But if that means that, for instance, this enterprise has also a service center in Spain, and it will mean that much more work will go to the service center in Spain, that can mean actually that will also have an impact in another country, being Spain, and that it will be a transnational matter. Well, you may expect that it will only have an impact on staff in the Netherlands. So it definitely broadens the scope of transnational matters, and I believe also it will result in European Works Councils claiming their rights earlier after this change will be implemented in local law. Another change relates to confidentiality. That's always a sensible topic because there's always a tension within the European Works Council framework between the balancing of the company that actually would like to protect sensitive information on one hand, and of course dealing with employee rights to be informed and consulted on the other hand. And actually, as the situation is now in many countries, confidentiality is imposed too broadly on European Works Councils, which makes that it's very difficult for European Works Councils to still say that they have meaningful consultation possibilities, and that also undermines trust. So the revised rules actually seek to create a situation that information can only be withheld by the company or can be seen as confidential if objective criteria have been set. And also, the confidentiality can only be upheld as long as these restrictions should take place. So these objective criteria should be implemented in local law, and that's something that also will need to take place for the Netherlands. Well, in addition to that, there's also better access now to justice. That's in particular countries outside the Netherlands, maybe more a problem than in the Netherlands. But actually this whole change is meant to give stronger rights to the European Works Council to start procedures and also to do that in a timely and effective manner. It also means that more dissuasive penalties can be imposed, so that's also something which will take place, financial penalties, and that's also something that will be implemented again in local law. Yeah, how to proceed and to finalize this one is actually that the member states of the EU have 2 years now to implement the new directive in local legislation, and then an extra 1 year to make sure that it can be applied in the respective countries. So if you do have European Works Council, please do check your EWC agreement, because it's very likely that changes need to take place on that agreement.
Right, thank you. I'm moving on with the changes with respect to the CLA for temporary workers. Before I go into that, I also want to point out that, a couple of changes are coming up for temporary agencies, but also for temporary agency workers, and especially, of course, organizations that hire temporary workers. So basically, a couple of changes is 2026, but also in 2027. There's now a new law announced for 2027, in which there becomes a new system, a permission system for temporary agencies, temporary employment agencies. They will need to obtain a permission from the authorities in order to become a temporary employment agency, in order to not hire, but in order to employ temporary workers. And in order to do so, they will need to obtain a declaration of good behavior for the company. So the legal entity needs to obtain such a declaration. Also, they will have to make a safety deposit from, I think, 50 to 100,000 euros in order to make sure that there are any discrepancies that they can pay for that. So basically, it becomes more difficult to start up a temporary employment agency, but also there are hefty fines for not only the temporary employment agencies, but also for the organizations that hire temporary workers, from not certified temporary employment agencies. Are difficult words, difficult combinations. But so that's one, and that law likely will be implemented as per the 1st of January 2027. So companies still have 1 year to prepare themselves for that. Another one, and that's the one on the slide, is the CLA for temporary workers, because there have been some significant changes to that CLA. And I've pointed out I think the most important one for now. I will not go in all the details about the changes that are being made. But I think it's important to first point out the introduction of equivalent working conditions for temporary workers. And we now know the so-called inlaners beloning in the CLA. So those are a couple of aspects of remuneration that should be equal to the worker that works within the company of the organization that hires the temporary worker in a similar or same position. And now they will go further on that, and they say, okay, you need to pay more equal pay. And you can almost no longer deviate from the pay that you pay to a temporary worker and the pay that you pay to someone that is being employed by the organization in the same or a similar position. And does that have to be the same for every employment condition? No, there's a distinction being made in the CLA between an essential and a non-essential employment condition. And the sum of those employment conditions, so the sum of the essential employment condition, must be the same as, like I said, the worker that works in the same or similar position within the company that hires the temporary worker. And the same goes for the non-essential employment condition. So how does it work out in practice? We'll have to a little bit see, because of course not every employment condition can be valued in money, for example. I'm curious to see how companies will deal with that. But that's what's important to take that into account. And I think for HR, it's important that likely temporary agencies will try to obtain more information from companies with respect to employment conditions, and it can be collective regulations, provisions in the CLA, and how do you compensate your employees, and we have to make sure that temporary workers are paid equally. This change will already be implemented as per the 1st of January, so next month basically, which means that likely most organizations are already working on, okay, how can I make sure that the temporary worker is being equally paid in line with the CLA. So that's something to definitely take into account. Another change in the CLA is the change in the pension plan of temporary workers. So I just said the essential and non-essential employment conditions has to be the same for the temporary worker in relation to the same worker in the organization. The exception there is with respect to pension, because basically in practice that's quite difficult to provide the same pension for a temporary worker. So the CLA provides with its own pension scheme for temporary workers, and that's being changed for the benefit of the temporary worker. Another change in the CLA is that phase B, the so-called phase B of the CLA, will be shortened from 3 to 2 years. So a little bit of background. Under Dutch law, we have the so-called chain of contracts, which means that you can provide an employee with a certain amount of contracts for a certain period of time. The same applies for temporary workers. That chain of contracts is more flexible than for regular employees. And the new CLA says, okay, for phase B, that period will be shortened from 3 to 2 years. Also an important one is that the interruption period between those contracts. So for example, you have a contract for 1 year that's being interrupted for more than 6 months. And after that, you enter into a new contract. Then the chain of contracts starts all over again. And now the CLA states that the interruption period between contracts will be changed from 6 to 60 months. That's not a typo. It's 60 months. So it's 5 years. So if you hire a temporary worker again within 5 years, then the chain of contracts still apply. So likely this will be quite difficult also from an administrative point of view, because you will have to make sure that you know the history of the employee 5 years back in order to make sure that you are compliant with the rules regarding a chain of contract. But it's definitely something important to take into account. So that's basically what I think the 3 most important changes for the CLA for temporary workers as per the 1st of January next year. So let's move on, and some other highlights with respect to legislation that we want to point out is that the European Union Directive on Pay Transparency is delayed by the Dutch government. So they say, okay, implementation of that directive, the deadline for that will be the 1st of January 2027. If I'm remembering correctly, it was the 1st of June or the 1st of July 2026 was the most recent implementation date. We still haven't seen a written law from the government, so we're still waiting for that. But for now, it's good to know, okay, they've delayed the implementation. Another one that's also quite important is the compensation scheme for the transition allowance that will disappear for large employers as of the 1st of July 2026. And a large employer is someone who employs 25 or more employees, basically. So that's also important. So as from the 1st of July, you no longer get your transition allowance compensated in case of long-term sickness of the employee, and that you are obligated to offer that employee with basically a termination. We'll have to see how that develops, but for now it's good to know that that compensation scheme will disappear. Furthermore, internet consultation. So there was a legal proposal regarding the assessment of reintegration efforts and the advance payment for the visa. What that basically means, or I think the most important takeaway from that legislation, is that the government says, okay, we want to make sure that if the company always follows the advice of the company doctor, you will not get a wage penalty from the UWV in relation to long-term sickness. So what happens now is that in some cases, in some exceptional cases, I have to say, but still, the employer gets a wage penalty while it followed the advice of the company doctor, and that the UWV decides differently and says, okay, you haven't followed the second track properly, for example, and we still think that justifies a wage penalty. And with this proposal, the government says, okay, if you follow the advice of the company doctor and you've always done that, that means that you don't get a wage penalty from the UWV. So that's important to know. The law is still not applicable, but it's in the making. All right. I think those were the updates with respect to legislation. So let's now move on to our main topic, and that's basically for today, changing employment condition. And I think what we see in the last couple of months, last year perhaps even, is that a lot of employers say, yeah, we want people who have been working from home, working remotely, especially during COVID. I think everyone will remember that we were all working from home, working remotely, and employers had a lot of flexibility in that regard. That we see that at least Dutch organizations, but also American organizations, tend to say more and more, we want people back into the office. And we are looking at from a legal perspective, and we're always asking, okay, but if insofar, how can an employer change that employment condition, or is it even an employment condition? And can you say to employees that you have to go back because I worked, I don't know, the last 3 years from home, and now I have to get back into the office? Can you require that from an employee? And we're going to start. Marcel's going to start about, I think, tell us more about what is an employment condition, and do we have even a qualification of an employment condition?
Correct. Thanks. No, definitely. Yeah. So what we see in our practice, and quite some employers that wish to change employment conditions, but also quite some situations where there is disagreement about the question whether a benefit qualifies as an employment condition. So therefore it's good to focus on that particular question, what is an employment condition? And let's say the most easy part of that answer is to say, well, you can look in the employment contract, you can look in the employee handbook, and there you can see employment conditions which are actually agreed between the parties, employer and employee, and that can relate, for instance, also to position, place of work. And so also to make clear that it does not necessarily have to be a financial or financial related benefit in order to qualify as an employment condition. And maybe to further explore that one, it's important to know that there are actually distinctions in employee benefits that we do have. So first of all, we have primary employment conditions, which is actually the core of the employee compensation. That's mainly relating to salary, it's relating to working hours as well, it's relating to the number of vacation days that an employee has. And of course, we should not forget pension. And so these are actually the core employee benefits that are considered to be the primary employment conditions. Then there is a second layer, and that's actually what we call the secondary employment conditions. So these conditions consist of benefits that more or less supplement the primary employment conditions, you could say, and they normally also relate to a more financial or material advantage for the employee. And then you can think of, for instance, cost reimbursements, or sometimes a lease car, company car, that is actually granted to an employee. Then the third layer is actually what we call tertiary employment conditions. And that's actually more of, let's say, facility which is provided or provision that helps the employee to take care of their well-being. And so normally not directly related to a financial aspect in its nature. And so, for instance, you can think about a contribution to a gym membership, to say so. And why is the distinction between the different types of employment conditions relevant? Because the more important, you could say, the employment condition is, in general, the more difficult it is to make changes in these employment conditions or to even withdraw it. If you can move to the next one.
Yeah.
Great. Well, then it's not only good to know what is an employment condition, but also to know what is actually not an employment condition. So we also make a distinction between employment conditions on one hand and situations where you can speak about rights that the employer has to issue instructions. And then it relates, for instance, to rules relating to conduct of the employee, or when it relates to safety regulations, for instance. And so these are actually situations where you can say, as an employer, we have the right to instruct you and that you will obey to these rules that we have within our company, and that is for a specific reason. It can again be safety or relating to the conduct that you expect from your staff members. So when we talk about this specific element, and that you normally also see, for instance, in an employee handbook, or one of the attachments maybe of this handbook, then it's not considered to be an employment condition. And that also means that there are broader possibilities for the employer to, first of all, say it's not an employment condition, so I can also change this unilaterally, and I do not need your consent from you, employee, to change that. Is it always necessary that an employment condition should be something in writing? No, that's not the case, because an employment condition can also arise in practice as a result of what we call a particular course of conduct. In Dutch, we name it a gedragslijn. And in that situation, a acquired right may deem to have arisen. And if that is the case, if the answer is something has become an acquired right, that also means that it has become an employment condition. And so, in answering the question whether something is an acquired right or not, it's still important to know and to get a finger behind the situation. Is the employee reasonable, entitled, and should the employee be able to rely on this particular benefit in future as well? Whether that is the case, and that's definitely a lawyer's comment, I do know that definitely depends on the circumstances of the case. But let me elaborate on that one. If you can move on to the next one.
Okay.
Oh, sorry, that's already good to me. Let's jump on some relevant case law. And we do have a very important decision of the Supreme Court, so the highest court that we do have in the Netherlands, which is already in 2018, which is called the Pontmeijer case. And actually what the Supreme Court did in this case is provided 6 guiding principles in order to assess whether a benefit which has been granted or a situation that has been allowed to exist by the employer has become an acquired right or not. And actually the first factor that is taken into account is the content of the course of conduct that has been maintained. And so you definitely have to look at what is it actually, and also how important is it for the individual. Another aspect that's taken into consideration is the nature of the employment contract and also the respective positions of employee and employer. So for instance, if you are in a management position, or maybe you are in HR, and then you are in a different position, and maybe also in a position to better negotiate about a certain situation, maybe also to better communicate about certain elements, than compared to a more blue-collar worker, to say so. And so that's also a factor that is taken into account in the assessment whether something has become an acquired right or not. The length of the duration during which a certain course of conduct has been applied, that's also a factor that has been taken into account. Is that only for a few months? Well, then it's less likely that something has become an acquired right compared to a situation which may already have been the case for years, maybe more than 10 years, for instance, that people received a bonus or some other kind of benefit. The fourth element in the guiding principles is the statements, the communication that also took place between the parties, still in relation to this course of conduct. So what has been communicated? Is there any communication at all? Did the employer, for instance, make clear to the employee that something was just for the time being, that the employee could not expect that this right would also exist in, let's say, the year after? All these elements are also important in this discussion. Also the nature of the advantages or maybe disadvantages to the employee are taken into account, or for the employer possibly. So how important is this particular benefit for someone? And for instance, someone claiming that this person could work remotely, maybe we will come back on that one later with some case law, can be an important factor for an employee because then this person does not have to travel, for instance, to the office. And the last one, the nature and the extent of the group of employees towards whom this course of conduct has been applied. So does it only relate to one single person, or does it relate to a group of employees, all in the same position, who have been all treated in the same manner? That's also something which is one of the factors in itself that will be taken into account. All right. Does it then also mean that all these factors are equally important in the discussion and assessment whether something has become an acquired right? Well, actually, the court did not say that this benefit or this factor is more important than the other. So it's definitely something which is seen as a total. And it does not necessarily mean that, for instance, the duration is more important than the position of parties in that assessment. And what we see in practice is actually that the lower courts do take into account this decision of the Supreme Court as the starting point in making this assessment whether something has become an acquired right. And whether that also means that it has become an employment condition, because that's still the relevance of this assessment. If it is an acquired right, it is an employment condition, and that also means that you cannot just easily change it, withdraw it, and take it away from an employee or employees. Well, maybe briefly we're going to try to give some examples also based on case law later on as well, but very briefly to give you some examples whether something is an acquired right, yes or no. For instance, an annual salary increase which has been granted over years, for many years, without any condition being attached by the employer, and so just give the merit increase on a yearly basis, which was actually withdrawn from one to the other year. In that situation, the court decided that yes, it was an acquired right of the individuals to have this merit increase. Same situation relating to a car which was provided to an employee for over 10 years, even though this employee was not entitled to a company car based on the applicable car policy. Also in that situation, the court ruled that it was an acquired right and therefore also an employment condition. Well, there's also, of course, a downside of that, court's ruling that something is not an acquired right. And that was, for instance, the case in the situation where 100% of the salary was paid during sickness, while 70% was actually agreed in the employment contract. And the employee was actually claiming, I should be entitled, remain entitled to 100%. But in this specific case, the employee could not prove that this was a consistent course of conduct from the employer to pay full during sickness also to direct colleagues. So in that case, it was not an acquired right and therefore also not an employment condition. All right, then the next chapter is actually up to you to explain how does it work if something has become an employment condition where there are possibilities to change it.
Yeah, now we have established that what is an acquired right and what can be seen, when is there an employment condition. And then the question arises, okay, how can we, if we want to, can we change that? And before I start with that, I saw a question and I forgot to mention it at the beginning, whether we will receive the presentation. Yes, you will receive the presentation afterwards. So we'll make sure that you get that. So yeah, changing employment conditions. There are a lot of ways to do that, and I've pointed them out in the sheet. We'll quickly run through them. I marked a couple of those red because I want to today, because it goes. We can talk all day about changing employment conditions, and believe me, I would like to do that with you. But for now, we're going to do it in a couple of minutes. I'm just going to discuss with you the highlights of a change clause. So Article 613 of the Dutch Civil Code. And changing based on good employer and employee practices. So based on Article 611 on the Dutch Civil Code. And I'm going to give you an example of how can employment conditions be changed based on the law, basically. So before I start with that, I'm just going to run through all the other options that you could have as employer. The first one is explanation, and that can be a bit confusing, but what we see in practice is that a lot of discussion can arise from how can we explain a certain contractual provision in the employment agreement, for example, because under Dutch law we look at the meaning of parties, the intention of parties with what they included in a contractual provision. So we don't explicitly look at the text of the provision, but we also look at the intention of parties beyond that text. So in that way, you can say, okay, I'm giving this interpretation to this contractual provision, while the employee gives another explanation or interpretation, and in that way, another form of employment condition can apply in a certain way. The second one is the right to give instructions, and that's also based on the Dutch Civil Code. And Marcel already mentioned that before, and it's of course about applying rules of conduct. So do you have to wear a hairnet within a production area? Do you have to wear a helmet within on a building site? Things like that, and those can be seen as the right as you as employer to give instructions. And it can be a little bit of a gray area. When is it an instruction, and when can it be considered an employment condition, for example? And what you see in case law is a lot of discussion about people who work in irregular times. So people who work in shifts, for example. And they say, okay, I already worked for like 5 years in a certain shift, but within the company there are also other shifts that people can work in, and can it then be considered an instruction to work in another shift, or can it be considered an employment condition to work in a certain shift? And of course, that's important for most employees because connected to that shift is likely a percentage of shift allowance. So the decision to instruct someone to work in another shift can have a financial impact. And unfortunately, there's no black and white answer on whether or not changing a shift for an employee, it can be considered an instruction or can be considered an employment condition. And you will have to look at that, also taking into account the points that Marcel just made. Then, of course, mutual agreement, and that seems the most obvious one. We want to change or withdraw an employment condition, and we do that with the consent of the employee. And then also we have a couple of conditions based on the Dutch Civil Code, so 258 of the Dutch Civil Code, Book 6. And that applies that you can change employment conditions in case of unforeseen circumstances. And it's quite exceptional. So I think during COVID, that can be qualified as an unforeseen circumstances. However, that does not justify that you can change any employment conditions you want because of the fact that it is COVID, of course. So there's a high legal threshold to make use of that clause. The upside of that is that you can apply that clause with retroactive effect, which means that you can make a change with retroactive effect. And you will see that with the change clause under Article 611, it means that you can only change as from a certain moment in the future. Of course, also changes can be made relatively easy within a collective labor agreement. Of course, you have to agree such an agreement with unions. So that makes it, on the other hand, slightly difficult. However, I think a collective labor agreement is the most easy way to change employment conditions for a whole group of employees, of course, that are bound to that CLA. There are a couple of details on that. Does the collective labor agreement has a so-called minimum nature or a standard nature? But a collective labor agreement is, I think, the most fast and easy way to change employment conditions for a large group of employees. Then we also have 248 of the Dutch Civil Code, paragraph 2 of Book 6. And more or less that's like the general clause, because we under employment law we know Article 611 of the Dutch Civil Code, based on which we can change employment conditions, and this article is more or less the equivalent under we call it civil law, but it's also being used in employment cases, but it's quite exceptional. Then we also have the incorporation clause, and incorporation clause can be, for example, the clause in which you state that applicable to this employment agreement is also the personal handbook, for example, of the employer. And in that way, you can also incorporate employment conditions into the individual employment agreement. Then also we have dismissal due change. So we call that wijzigingsontslag. And I think and most recently you see that in cases of long-term sickness, for example. And the Dutch Supreme Court had a couple of rulings and stating rules about, indeed, if someone, for example, continues to work for the company after long-term sickness, for example, and you reduce the amount of hours, you change the position, for example, that under certain circumstances you can, for a part, terminate the employment contract. So, for example, when someone goes down from 40 hours per week to 20 hours per week, that you can make arrangements with the employee to terminate the employment contract for that 20 hours, and that the employee under circumstances can also be entitled to payment of a partly transitional allowance for that 20 hours, for example. So I think those are the ways to change employment conditions. Like I said, I'm moving on with, I think, the three most important ones, or the three most frequently used. Not the first one. The first one is quite an exception, because that's changing employment conditions based on what is being said by law. And I've included an example of that, and that's the Wage Formation Act. I don't know, did you know the Wage Formation Act? It's not very common, No, and the Wage Formation Act foresees an option for the minister to say that in a sudden emergency situation in a national economy, that basically the minister can lay down general rules concerning wages and other monetary terms of employment. This goes quite far, of course. It can only be applied for 6 months and be extended by another period of 6 months for maximum 1 year. And in my memory, it hasn't been used by the minister. And I think, what kind of circumstances do we talk about? I think if we are at war, for example, that could be a reason to say for the minister, I'm going to change employment conditions with wages, for example. So hopefully we don't get into that situation. But I think it's good to know that, there are these kind of laws that can apply in certain circumstances. Moving on. So basically, the change clause is one of the most important clauses that have been used in order to change employment conditions of employees unilaterally. And I just included a simple one that we see a lot in employment agreements. So basically saying the employer is authorized to unilaterally amend the employment contract. And as it stands there, it looks quite simple. And you can say, okay, based on this provision, I'm authorized to change your employment conditions unilaterally. I don't need your permission. I can just do it. Unfortunately for the employer, there are a couple of conditions attached to such a change. And that's included in 613 of the Dutch Civil Code, Book 7. And you can only you have to invoke a written clause, and you have to have a compelling interest in the amendment of the employment condition. First of all, you have to have that compelling interest, and that would harm the interest of the employee. So there's basically what you do is weighing up interest, whereby the employment agreement can only be changed to the disadvantage of the employee is sufficiently compelling interest on the part of the employer justify this. So basically, I've also included some case law, or at least a ruling from the Dutch Supreme Court, in which it states, okay, this is about I think a wage sacrifice, so a decrease of the salary of the employee. And basically what the Supreme Court is saying, that you have to have a very good compelling reason in order to ask from an employee a wage sacrifice, because that's a direct impact on the financial income of the employee. So you have to have a very good reason to say, I want to change that employment condition. And the Dutch Supreme Court says, okay, that you should weigh those against each other. So the more infractional the interest of the employer is, or the change is, you have to weigh that against the interest of the employee. And you can imagine that, of course, a wage sacrifice is quite significant. So you also have to have a very compelling reason in order to change that employment condition. And for example, in this case, the Dutch Supreme Court established, okay, there was no economic necessity for the wage sacrifice from the employer. So basically what we see in practice, if you want to ask an employee to, if you want to decrease the salary of the employee, you have to be in financial bad weather as employer in order to make sure that you have a far enough compelling reason. And even that could, in some cases, is not enough. I think you have case law in which the employer already restructured for like 3 times. And after that say, okay, I now want to decrease collectively the salary of employees in order to make sure that we make it as a company, and that was a sufficient compelling reason for the employer to change that employment condition. So quite a high threshold in order to change employment condition based on Article 613. But also important takeaway from this article is that this is the clause in which you unilaterally change employment condition. And like I said, you have to have the compelling reason, and you have to proportionate that to the interest of the employee that's being harmed. But it is possible. And a good example, because I found it quite creative from the employer, was a ruling from the court in Amsterdam. And the employer said, okay, I had heavy losses for several years in a row. And what I noticed is that a large group of employees had outdated IT skills. And therefore he said, I have a compelling interest in abolishing the anniversary bonus scheme, which would have a financial impact on the employees involved. But the employer said, I want to invest the savings that I get from abolishing that scheme. I want to invest that in a budget for training and retraining as employees. And basically the court said, we see that there is a commercial necessity because of the heavy losses in the previous years. And that you also have an interest to improve the employability of your employees, and therefore we qualify that as a sufficient interest in abolishing the anniversary bonus scheme, And of course, the fact that the employees were counting on this benefit is not sufficiently weight to outweigh the employer's compelling interest. So in this case, the Court of Amsterdam weighted those interests and said, okay, as employer, your interest is more compelling, and therefore you can unilaterally change that employment condition. So it is possible. So the next one is about changing in another way. And basically this comes into play when we see in employment agreements that there has not been a change clause being agreed upon. And then basically, can you not change any employment conditions if you don't have a change clause? No, you still can. But you do have to do it through another legal way, let's put it like that. And we do that based on Article 611 of Book 7 of the Dutch Civil Code. And of course the case law in that respect, because Article 611 states, you have to act as a good employee, you have to act as a good employer, and what kind of rules can we can follow from that, and that has been done by the Dutch Supreme Court. I'm gonna quickly run through this because we still want to discuss some case law with you. So basically, what is important to know is that starting point to change an employment condition through 611 is that you have to get the employee to accept this change. So basically, you first need to make sure that there are changed circumstances at work, which led to the employer wanting to change an employment condition. And subsequently, you have to provide the employee with a proposal that you want to change the employment condition. And you can think out of a phase-out scheme, for example, if you want to change certain employment condition, and that basically that the employee can no longer say that you in reasonableness cannot deny the proposal of the employer. So basically that's how you look at it from I think from a legal perspective. 611 and 613 do not differ that much from each other. So if you change through 613 or 611, it doesn't change very much. However, the process is quite different, because 613 says, you can unilaterally change an employment condition and you don't need the consent of the employee. While with 611, that's the case. And the legal threshold in that case is that, the employee in reasonableness cannot withhold his consent to accept a proposal from the employer. That with respect to theory. And now we're gonna put that into practice and discuss some case law that I think we saw in the recent year about how changing employment conditions. I think you were gonna do the first one, Marcel.
Yeah, indeed, because I think it's also important to show what is the impact in practice. And what we did not discuss yet is actually the role of the Works Council when it comes to changing employment conditions. And an interesting case was quite recently, in September this year, was the court in Oost-Brabant. It relates to the company Caterpillar. And to briefly explain the facts, Caterpillar started with a pilot to make possible that employees could work from home. So they introduced a pilot with a working from home policy. I think it was in 2016. The pilot worked out well for both the company and the employees, so they decided to implement it as part of the employment conditions. And then at a certain stage after COVID, then I make some steps actually in the facts. The company decided that it would be good if employees would be encouraged to get back to work. So that was also communicated to staff, and since they did notice that not that many employees did take up that notification to go back to work, they said, from now on, we're going to oblige people to be back in the office for at least 3 days per week. And later on, they said, we're going to withdraw completely the working from home policy that we have within the company. And what happened at that time was actually that the Works Council raised its hand and said, in that situation, you cannot do that. You need to involve us, and we do have a right of consent. So without our consent, you cannot implement this within the company. So that was actually also what the court had to give a decision on. And the court said, well, first of all, this is an employment condition, and second, this is also a change relating to working conditions, working circumstances, I should say in particular. Because if we look at the situation from the perspective of the court, we do need to assess whether this proposed decision of the company relates to working conditions, and also the purpose of the scope of making that change is very important. And actually what the court said in this situation is, well, this return to the office, the RTO decision, is to actually modify the existing working conditions, and therefore it does require, based on Article 27 of the Dutch Works Council Act, the consent of the Works Council. So actually the Works Council was right that their right of consent should have been allowed, actually, which was not the case. And it's good to see that the explanation that the court also gave was how they looked at the working conditions. That they said, well, working conditions are fundamentally different. If you say, well, first of all, you had the freedom to work from home, and then you decide to say, well, no, it should be in the office because it does limit the flexibility of employees. It will have an impact on the way they have to do their work. They have to arrange certain things, maybe also privately, and to make sure that they can go fully back to the office again. And maybe also good to be aware of that even though the Works Council may give its consent to a decision or proposed decision to change an employment condition or employment conditions within the company, that in itself does not replace the individual consent that you may need based on what Peter just explained from the individual employee. So it will definitely help in the discussion and to make changes to employment conditions, but it still does not fully replace individual consent of staff.
Yeah. So basically, if you're not there yet, if you got the consent from the Works Council, it still backfire, and you don't get the individual consent of the employee, but it helps.
It definitely helps.
Yeah.
Sure.
All right. Thank you. Then I'm moving on. I had another working from abroad situation, and this is an employee who was working from Turkey with permission from the Dutch employer. So the employee had a Dutch employment contract. Started, I think, in 2023. First got a year contract, and after that an extension for 6 months. And in 2023, permission was granted to the employee to work from Turkey for a certain period of time. And at a certain point, a discussion arises between the employer and the employee regarding the duration of that period for which permission was granted. So for how long was the employee allowed to work from Turkey? And at a certain point, the employer says, that permission no longer applies and you will have to come back. And I instruct you to return to the Netherlands basically immediately. The employee refuses to do that, and then dismissal on the spot. So urgent reason for dismissal, instant dismissal for the employee for not following reasonable work instructions and a refusal to work. Then it comes for the court, and the court says, but if I'm looking at the communication, the correspondence between parties, it's still not clear how long permission was provided to the employee to work from Turkey. And the court also states in that decision that more or less comes at the risk and expense of the employer. As an employer, you have a responsibility to make clear arrangements regarding the duration of working from abroad. And when there's discussion about that, I'm gonna explain this in the advantage of the employee. And what happens during the court hearing is that the court asked the employer, why was there such a rush to all of a sudden ask the employer to return to the Netherlands? And it seems that the employee was pregnant and mentioned that to someone from HR in confidence. And that person from HR informed the employer, and the employer wanted to, the employee to return to the Netherlands immediately, because the employee also made it clear to HR I don't know if I see any future yet within the company. So therefore, the employer said, okay, I have a trust issue and I want you to return immediately. But the court says, yeah, that's not enough to qualify as an urgent reason for instant dismissal. And I think that's an explainable decision. So therefore, the court says, no, there's no urgent reason for instant dismissal. It cannot be considered a reasonable work instruction in this situation to return to the Netherlands immediately. And therefore, the court destroyed that instant dismissal. And the employee was paid out for the whole duration of the contract because they had a definite contract. And this court case was after the expiration date of the contract. So basically the court said, okay, I'm going to pay you for the full contract. And that's it. So that, was also, I think, a remarkable court case about working from abroad.
So we do one briefly?
Yeah, let's do that. We still have a couple minutes and we need to do some questions, but I think this one... Yeah. Is the
to maybe also end a little bit more more lightly actually, and this is actually a very particular case, and we all do know the signs of be aware of the dog. Well, this is also a situation of be aware of the dog, but then in a different situation, was an employee who actually started employment, and from day one actually this person took his dog to work, and he worked as a physiotherapist, and he was not the only one actually taking his dog. There were 6 other colleagues also taking the dog, so I think it was quite a cozy place to work.
Yeah.
And then there was a new manager, and the new manager said, well, we're going to come up with some new rules, and one of the new rules is actually that we're going to prohibit that people will bring their dogs to the workplace. This case actually went to court. It was summary proceedings, and maybe a funny element that the employee brought up during the court hearing was that he said, well, my dog actually has a positive effect also on the well-being of my clients, and also plays a role in supporting me in the therapy that I'm doing. Whether that is the case, that's maybe still a question mark, but let's say what the court did is the court did pay attention to the guideline principles, as I just explained in the Pontmeijer case, and came briefly spoken to the conclusion that in this specific situation, where the employee could bring his dog to work from the start without getting any signals that he cannot do that it had a negative impact on his work, and that this is considered to be an employment condition. So once again, be aware of the dog.
It's definitely a readable ruling, I think. If you want to have a full overview of how the framework of Pontmeijer is applied by a court, this is definitely one to read and to look up. I think we have 1 minute left. I saw that we had a couple of questions, but before we get to that, I want to point out to everyone that after the webinar, we would like to ask you to fill out our webinar evaluation. How do you rate us? And what do you like? What did you like? What did you not like? So we can use that for our future quarterly updates. So thank you already for that. Yeah. So basically, I saw a question, and I think that was asked in relation to the interruption period. Yeah. Is that the same with a leaver who is rehired within 5 years? So basically, yes. So the interruption period now is 6 months. So we have a chain of contracts. Interruption of more than 6 months means that we start all over again with the chain of contracts. But what the legislator is now saying is that, okay, we want to extend that period to 60 months. So indeed, 5 years. So someone that's leaving the company and after 3 years is rehired, it could be that the chain of contracts still applies. So it's important to take that indeed into account as employer and as temporary agency.
Yeah. Now, so a question whether that helps. That's, I think, a question relating to the topic of whether something may become an acquired right or not. And does it help to include a clause in the employment contract or handbook where you do say that, for instance, a bonus, that if it is paid in any given year, that it will not give a right to the employee for payment of this bonus in this example in a subsequent year. Well, yes, it definitely helps if you can fall back on something which you have put in writing to the employee. So that's also one of the elements that will be taken into account based on the Pontmeyer criteria. But it is not helping you if this is still something which takes place for, let's say, many years. So if you do pay bonus for, let's say, more than 10 years, and the criteria have not maybe always been met, but still a bonus has been paid, then even this clause may not help you at the end to say that this should not be considered an acquired right. So yes, please include, but it's not the ultimate winning argument at the end if this is taking place for a long time.
All right, thanks. I think then we're going to wrap up. And if you have any questions after the webinar, please feel free to ask them. These are our contact details. Thank you for at least filling out the webinar evaluation. Thank you for watching. And hopefully we see you again in 2026.